The Supreme Court just upheld the ATF's rule on regulating unfinished frames and receivers, essentially their 80%er rule, so we need to talk about what happened in this decision and what potentially will happen now going forward. Now before we get into the video, I want to thank the new sponsor on this channel, which is Montana Knife Co. If you're into high quality American-made knives, you need to check out MKC. MKC was founded by one of the most experienced master bladesmiths in the entire world, whose name is Josh Smith. Josh made his first hunting knife at just 11 years old and became a master bladesmith at just 19. There are only about 150 of those individuals in the world, so you know you're getting high quality knives with MKC. These knives are absolutely amazing and they always sell out fast. I'm talking about they sell out in just minutes. And they have some really big news. MKC is dropping 5 brand new tactical knife models on March 27th. I've had the luxury of trying out the TF24, the War Goat, and the TF24. I actually run the War Goat on my range belt, so this is the knife that's been on my range belt for quite a while now. I absolutely love it, but like I mentioned, they're dropping other models as well, like the VF24 and the TF24. I cannot recommend them enough. Like I said, they sell out super fast, so if you want to get one of these knives, I highly recommend you sign up to the newsletter, and that will be linked down below in the detail section and the pinned comment. So thank you again to MKC for sponsoring this channel. I recommend it to you guys because these are working knives for working people. As I mentioned in the intro, in this video, we have some very big news out of the Supreme Court. The Supreme Court just upheld the ATF's frames and receivers rule, essentially their 80%er rule, and they upheld it in a 7-2 decision. The case we're going to be talking about in this video is Vanderstock versus Bondi. This is a case we've been following for a long time, and the Supreme Court just issued their decision upholding this ATF rule. They found that the ATF's rule is not facially inconsistent with the GCA, and therefore they upheld it. Now, Justice Gorsuch wrote the majority opinion, and he was joined by Barrett, Roberts, Kavanaugh, Jackson, Kagan, and then Sotomayor. Only Alito and Thomas dissented in this case. This, of course, is an unfortunate decision. The only positive you could say with this is that it was not a Second Amendment challenge. It was more on the Administrative Procedures Act. I anticipated after listening to those oral arguments that this was probably the way it was going to go, but I did not see Kavanaugh and Gorsuch jump the line to uphold this 80% rule, so we need to talk about what they found in this decision. Now, Justice Gorsuch, writing for the majority, stated that kit qualifies as a weapon because, 1, artifact nouns like weapon often describe unfinished objects when their intended function is clear, as with a disassembled rifle. 2, the statute treats starter guns as weapons, though they require conversion work. And 3, the statutory text contemplates that some things short of fully operable firearms qualify as weapons. The kit also satisfies the statute's second requirement, as it requires no more time, expertise, or specialized tools to complete than a starter gun, which the statute treats as readily convertible into a functioning firearm. While other kits may be so incomplete and cumbersome to assemble that they cannot fairly be described as weapons capable of ready conversion, the facial challenge fails because kits like polymer 80s clearly qualify. Now, in this section, the Supreme Court believes that the GCA's language covers certain complete kits and unfinished frames and receivers that can be easily assembled into functioning firearms. They find that some kits are so much similar to starter guns in what is required to assemble or change a starter gun that they still qualify as a firearm. The Supreme Court does not tell us where kind of that line is. Instead, they just point out that kits like polymer 80 kits fit within this definition, but other items may not. They go on to state that, like weapon, the artifact nouns frame and receiver may describe not yet complete objects. The statute uses this term to encompass some unfinished items elsewhere, as in section 923I's serialization requirements for incomplete weapons, silencers, and destructive devices. ATF has for decades interpreted the statute to reach some unfinished frames and receivers, and even the plaintiffs concede they have no quarrel with the ATF's prior practice of regulating those products. Accordingly, the statute authorizes the ATF to regulate at least some incomplete frames or receivers that take minutes of work with common tools to complete. While other products may be so far from finished that they cannot fairly be described as frames or receivers, the facial challenge fails because the statute plainly reaches some partially complete items. In this section of the opinion, the majority of the Supreme Court finds that there are some sections of the GCA that mention not yet complete objects could still be considered weapons or frames or receivers, and because of that, Since maybe some incomplete silencers or incomplete destructive devices or starter guns, since those still qualify as weapons, they believe that these types of kits that they see in their eyes are so readily convertible, are so easy to convert, those also qualify under the language. They also point out that the plaintiff here did not take issue with the ATF's prior practices on 80%ers, and so they say that that was conceded, and the ATF, as that concession is, the ATF has some sort of regulatory authority on some items, and since there is one item or maybe one kit that meets the definition within this regulation, all other restrictions and all the other items that are regulated, pass the facial challenge. They then address one of the more concerning points that was raised in this case about, where is this line and where maybe does this logic actually lead us? During the oral arguments, there was an issue raised that this broad interpretation could lead to maybe treating AR-15 lowers as actual machine guns because they could be easily modified to become a machine gun. The argument was that if an unfinished frame or receiver is a firearm within its own right because it could be, readily converted, without a lot of time, without a lot of tools, Judge Oldham in the Fifth Circuit raised the question, well, what about AR-15s? Couldn't you say the same thing about a standard AR-15 lower, that it is so easily convertible into a machine gun? The Supreme Court brushes that off by saying, well, the ATF told us that they wouldn't do that they would not treat AR-15 lowers as actual machine guns, and therefore we're going to take their word for that and not really consider this type of issue. They state that the government represents that the AR-15 receivers do not qualify as machine gun receivers, and this court's analysis of the GCA does not suggest that the ATF has authority to regulate them as such under the NFA. Now, one of the final things that they addressed in the majority opinion was the rule of lenity. Now, when it came to the rule of lenity, that indicates that when dealing with criminal statutory interpretation and potential ambiguous terms in that statute, the court is required to apply any unclear or ambiguous statute in a way that is most favorable to the people, not the enforcement agency like the ATF. But in this case, the Supreme Court found that the GCA is not ambiguous. Instead, they say that the GCA's terms cover 80%ers and there is no ambiguity. And based on that, the Supreme Court in a 7-2 decision upheld the ATF's 80%er rule. Now, there was some concurrences. One of the concurrences that I want to point out is Kavanaugh's concurrence. In his concurrence, he points out that the lines between weapons, parts, kits, and unfinished frames and receivers is really unclear. But for the government to go after someone, they would need to essentially show that the person willfully violated this law. And so Judge Kavanaugh actually emphasizes a lot mens rea, and that there needs to be that mens rea, the intent, the willful violation of the law to actually go after someone for violating the 80%er rule. Now, Justice Thomas, in his dissent, does kind of the classic Thomas thing, and he obliterates, the ATF arguments and kind of calls out some of his colleagues for using the incorrect type of analysis. In Thomas's dissent, he states that the government asked this court just last term to rewrite statutory text so that it could regulate semi-automatic weapons as machine guns. And there he is referencing the Cargill bump stock case. And then he states, we declined to do so. The government now asks us to rewrite statutory text so that it can regulate weapon parts kits. This time the court obliges. I would not. The statutory term frame and receiver do not cover the unfinished frames and receivers contained in weapon parts kits, and weapon parts kits themselves do not meet the statutory definition of a firearm. That should end the case. The majority instead blesses the government's overreach based on a series of errors regarding both the standard of review and the interpretation of the statute. Thomas then raises major concerns about the facial statutory interpretation that was performed by the majority. He points out that this could give some broad discretion to all agencies, not just the ATF, but maybe others, to regulate broadly in just broad categories of items as long as the rule that they put in place was created properly in a way that covers at least one item. He states that treating challenges to regulatory definition as facial challenges has substantial implications. If a regulatory definition survives APA challenge, so long as just one item it covers also happens to be covered by the statute it purports to interpret, it is difficult to understand how an agency would ever promulgate an invalid definition. So long as it imports the definition Congress laid out in the statute, the agency can sweep in whatever additional conduct it wishes. So what Thomas is really pointing out here in a way, in kind of a crude example, would be that if you took a test and maybe you answer at least one of the questions on the test right, then you would get 100% on the entire test. We wouldn't say that that is proper, but really that's what's happening here. As long as the rule that's put in place by this agency, as long as it covers one item lawfully under the statutory text, well, then the Supreme Court here is saying, well, all of the rule is therefore lawful, even if it captures other items that the statutory text should not cover. Now, you may be asking yourself, where does this leave us? Well, the rule was found valid by the Supreme Court under the APA. This was not a Second Amendment challenge. So one of the good things is, this wasn't a pure Second Amendment analysis. So there's always an avenue maybe to challenges based on the Second Amendment. But I don't really think that that's likely. Really now, if you were going to ask me what happens from here, the ball is fully in the hands of Pam Bondi and then Kash Patel. It will be up to them whether or not they want to rescind this rule, get rid of the prior administration's 80% attacks, and then also halt maybe all implementation of the rule until they determine what they really want to do with this. In my opinion, this is going to be the administration's first big test on what they actually will do when it comes to Second Amendment violations. If they do not stop this, and especially if they let rogue agents go after people based on 80%ers, that will tell us a lot about what this administration really is going to do when it comes to the Second Amendment. So unfortunately, that was the decision that was issued by the Supreme Court. Again, a 7-2 decision upholding the 80%er rule. And now we're going to keep our eyes on Pam Bondi and Kash Patel and make a lot of noise, make sure that they know of this decision and they know that they need to get rid of this ATF rule. So as we get more information, as things develop, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.